The Terms of Use for Priceline.com. This paper is a review of the Terms of Use for Priceline.com and is also the transcript to the class assignment submitted via YouTube. I will also have a reference page to cite my research. Hello, my name is Intella Fagan. Today I will be presenting to you a review and my evaluation of Priceline.com Terms of Use, the Priceline User Agreement. This agreement is also known as the Terms and Conditions, an agreement between the user and Priceline.com LLC, which can be found at the bottom of the website's homepage. This agreement describes the terms and conditions applicable to the services available through this site and details your responsibilities, thereby limiting the liability of Priceline.com and its third-party suppliers or providers. These include, without limitation, the airlines, hotels, rental car companies, and other suppliers that provide travel or other services through this site. Such third parties collectively referred to as the travel service providers. Priceline is owned and operated by Priceline.com LLC together with its subsidiaries, Priceline.com, and is part of Booking Holdings. Airlines, hotels, rental car companies, and other suppliers provide travel or other services through this site. Today, I will be covering these 4 topics. Is it a valid contract? Are visitors bound to it, or should they have to click I agree? If you have a dispute with Priceline, can you sue them? Why or why not? And last, the changes I would recommend. Priceline User Agreement states, by accessing any areas of the site, the user, which is you, agreed to be legally bound without limitation, qualification, or change, and to abide by these terms and conditions, which will constitute our agreement. Today, I will evaluate and review Part 1, Legal Action, and Sections A to F. This agreement starts with A, Arbitration and Dispute Resolution. This section talks about how Priceline will handle any claims brought against them or their affiliates. This section in the agreement seems to be the largest section of the agreement. I will touch on some highlights of the clause. The user agrees to give Priceline the opportunity to resolve the claim by arbitration. All disputes are resolved by an arbitrator instead of a judge or jury, and the laws of the state of Connecticut, where the company has its headquarters. In an article by Leah Rush, she said, mandatory arbitration clauses mean that you agree that if you ever have any problems with the terms of the contract, you will have a hearing where a neutral third party will listen to both sides and give a binding opinion or judgment. That may be reasonable, but it means you lose your right to go to court and have a jury trial. I will suggest here that the bottom line is to read any contract you sign in its entirety and double check for mandatory arbitration clause. They're always easy to overlook, but too important to miss. In Part B talks about disclaimer of warranties. This protects the site from liability. All content contained within or available through this site are provided to you on as-is basis. Priceline makes no representations or warranties of any kind, either express or implied. In Part C, we will cover general limitation of liability. To the extent permitted by law, in no event shall Priceline.com, including its respective officers, directors, employees, representatives, parents, subsidiaries, affiliates, distributors, suppliers, licensors, agents, or others involved in creating, sponsoring, promoting, or otherwise making available the site and its contents, collectively the covered parties, be liable to any person or entity whatsoever for any direct, indirect, incidental, special, exemplary, compensatory, consequential, or punitive damages, or any damages whatsoever. The indemnification and chargebacks. In this session, Priceline points out that you, the user, agrees to defend and indemnify Priceline and the covered parties from and against any claims, causes of action, demands, recoveries, losses, damages, fines, penalties, or other costs or expenses of any kind or nature, including but not limited to reasonable legal and accounting fees brought by you or on behalf of you in excess of liability described above, or two, by third parties as a result of your breach of this agreement, your violation of any law or the right of a third party, or your use of this site in violation of this agreement. E. Trademark and copyright notices. In this session, Priceline gives the users notice that the trademarks are not an endorsement of Priceline sites. The content of the site is protected under U.S. and international copyright trademark laws. Your use of and access to the site does not grant you any license or right to use any of the content on the site. It further states that the materials and content on the site, including without limitation, the information, text, software, code, photographs, videos, typefaces, graphics, music, sound, images, illustrations, maps, designs, icons, trademarks, service marks, logos, are written content, collectively content, and the arrangement and compilation of the content are owned by Priceline.com, Priceline.com's corporate affiliates, and the travel service providers. In section F, it covers claims and copyright infringement. If you believe in good faith that material or content on the site infringes your copyright work, you or your agent may send us, which is Priceline.com, a written notice under the Digital Millennium Copyright Act that includes the following information: a clear identification of the copyrighted work that you claim has been infringed, a clear identification of the material you claim infringes the copyrighted work, and information that will allow us to locate that material on the site, such as a link to the infringement material, your contact information so that we can reply to your complaint, preferably including an email address and telephone number, a statement that you have a good faith belief that use of the material in the manner complained of is not authorized by the copyright owner, its agent, or the law, a statement that the information in the notification is accurate, and under penalty of perjury, the complaining party is authorized to act on behalf of the owner of an exclusive right that has allegedly infringed. The written notice must be signed by the person authorized to act on behalf of the owner of an exclusive right that is allegedly infringed. Copyright infringement notifications can be sent to Priceline.com by mail, email, or facsimile as follows: Priceline.com LLC, with the attention of IP Counsel, and the address is 800 Connecticut Avenue, Norwalk, Connecticut 06854, legal@priceline.com. Now let's talk about the 4 topics I mentioned earlier in my presentation. First, let's talk about, is the agreement a valid contract? All that is necessary for most contracts to be legally valid are the following 2 elements. All parties are in agreement and something of value has been exchanged, such as cash, services, or goods, for something else of value. The most basic rule of contract law is that a legal contract exists when one party makes an offer and the other party accepts it. For most types of contracts, this can be done either orally or in writing. So therefore, the agreement between user and Priceline.com LLC is a valid contract because the user agrees to the terms of the use and Priceline is giving something of value. This was taken from Forbes.com. Are visitors bound to it, or should they have to click I agree? In the case of Adam Singer versus Priceline.com Group, Priceline Group Inc., plaintiff Adam Singer has brought a suit against the defendant, the Priceline Group Inc., which is Priceline, alleging breach of contract, breach of implied covenant of good faith and fair dealing, and unjust enrichment claims following the additional costs incurred on his vacation. In 2011, the Priceline website did not require a customer to click through the hyperlink to the terms and conditions in order to place a bid. This was taken from the U.S. Government Court, ECF.CTD. But after reviewing the terms and conditions, in my opinion, it appears that Priceline has a browse wrap agreement where the consumer has to click the I agree button prior to viewing the contract. Some service providers seek your agreement by requiring you to click the aforementioned I agree button after being shown the agreement. Example, in the click wrap agreement. Whereas other service providers alternatively try to characterize your simple use of their website as your agreement to set a terms and conditions buried somewhere on the site. Going right into my next question, if you have a dispute with Priceline, can you sue them? Why or why not? In this case, I would have to answer no. The agreement states that there is a mandatory arbitration. It requires that any and all claims must be resolved by binding arbitration or in small claims court, and it prevents you from pursuing a class action or similar proceeding in any forum. These limitations apply to any claim against Priceline, its subsidiaries or affiliates, or any travel service providers or companies offering products or services through the site. The changes I would recommend that Priceline place a link on their terms and conditions in a very conspicuous place on the site that the user do not have to search for it. Some place that they can see it upon entering the site. Another suggestion is to possibly change to a click wrap agreement where the consumer clicks the aforementioned I agree button after being shown the agreement. Other than that, Priceline has covered all bases to protect themselves and its affiliates, vendor, service providers, and associates in its user agreement. Thanks for your time today. I hope this was an informative presentation to you.